Hello and welcome to SWS Civics course, Civics with SWS. And in this video, we are going to be looking at the important chapter of the Supreme Court. In fact, there are two parts to the judiciary part of the civics syllabus. The first one deals with Supreme Court and the second one deals with the High Court and the subordinate court. So what is special about these two chapters is that this would require a certain level of remembering terms because these are legal terms. This is legal language. So you need to be a little careful about that so that you quote correctly. So the keywords become more important in these two chapters than in any chapter so far in the civics syllabus. Shuru kare. This is the Supreme Court of India. You would have seen it in the newspaper, on television channels, right? This is located in New Delhi. This is known as the apex court. Apex court means the top court of the country. That's the other term which is used for the Supreme Court. It is the judiciary is independent in this country. That is, it is free of the interference from either the legislature, that is parliament, or the executive, that is the government. Okay, these are two salient features of the judiciary in our country. Now, the single integrated system of judiciary. Now, what does this mean? This is important. It's an important phrase. Now, as part of the single integrated system of judiciary, the Supreme Court is at the head of the judicial system because, as I said, ये topmost court hai. This is the apex court. Okay. The second part is that there are no separate sets of laws. That is, there is a single civil and criminal law system that operates in the country. ऐसा नहीं है कि Supreme Court will operate on a certain set of laws and high courts or any other court will operate on a separate set of laws. ऐसा नहीं है. It is the same law. It is the same penal code. It's the same set of criminal and civil laws which are on the basis of which judgments are given by either the Supreme Court or the High Court or any of the lower courts. Okay, so there are no separate sets of laws. I'll explain each and everything in detail, so please understand this. The videos of the judiciary are very important. Third part, there is a system by which the appeals are filed from the lower court. Agar aapko koi dikkat ho, to you will go to the lower court first, right? Say the Metropolitan Magistrate Court or the Sessions Judge or the District Judge, right? Agar wahan par aapko, you don't get a favorable verdict, then you will go to the High Court. Wahan par bhi nahi hota, you go to the Supreme Court. So it is a case of the appeals are filed from the lower court to the higher courts. Okay. There is a common mistake which many of your seniors made was to confuse the question on a single integrated system of judiciary with independence of judiciary from the executive. These are two separate things. Please do not get confused with legal language. I'm again cautioning you. Okay. Now, why is an independent and impartial judiciary required? I mean, why couldn't the makers of our constitution say judiciary will also be part of the government, right? We do have a law minister, right? The reason is to protect the rights of the individuals from the executive or legislative interference. Because if I criticize the government and the government sends this person to jail, then as it has on many occasions, then the only opportunity for that person to take help is from the judiciary, which is supposed to be independent. If the judiciary also was part of the government, then it will say, "Arey jo government ne kiya theek hi kiya hai, tumko to jail mein hona chahiye," hai na? But now you can appeal to the judiciary and say that on basis 1, 2, 3, 4, I should not be sent to jail. So please help me. So the judiciary is independent of either the legislature or the executive interference. Understood? The second reason why India has an independent and impartial judiciary is because it needs to ensure division of powers between the legislature, executive, and judiciary. These three should be three separate organs, right? These are three separate estates, which is why the press is called the fourth pillar of democracy. These three are the three pillars of democracy, right? And they should be independent of each other. There should be checks and balances, but they should be largely independent of each other. Third point, for protection of democracy and human rights. Okay, so these are three important reasons why India has an independent and impartial judiciary. What is the composition of the Supreme Court? It has a Chief Justice and 33 other judges. आपके अगर book में 30 लिखा है तो it means it has not been updated. Okay, the figure is now 33 judges plus the Chief Justice of India. 1 minute. I was going to sneeze. Okay, Chief Justice plus 33 other judges. I remember one of your seniors asking me, is the Chief Justice of India is the same as the Chief Justice of the Supreme Court? Yes. The Chief Justice of Supreme Court nahi bolte hain, they are called the CJI, the Chief Justice of India. Only Parliament has the right to increase the number of judges. Supreme Court cannot say कि अरे 33 बहुत कम है, 35 कर दें, okay, दो और लोगों को अपॉइंट कर दो, ऐसा नहीं होता है. Only Parliament has the right. So Parliament का उस तरह का कंट्रोल रहता है जुडिशरी पे, but it cannot interfere कि what judgment will those extra judges give, that cannot be decided by the government. Only these kind of powers the government has. Okay, I hope this is clear. Now, how do you become a judge of the Supreme Court? I'm deliberately going a little slow in this because I don't want you to get confused. These are important chapters. Now, you need to have been a judge of the High Court for 5 years, or an advocate practicing in the High Court for 10 years, or be an eminent jurist. Eminent jurist ka matlab hai someone who has, whose knowledge of constitutional law or criminal law or civil law is considered to be excellent. There have been such eminent jurists, Ram Jethlani the, Soli Sorab ji the, who are considered to be eminent jurists, right? So they can also be appointed as judges if they so want. Otherwise, High Court of, say, Karnataka High Court or Kerala High Court or Calcutta High Court, say, judges are promoted to become the judge in the Supreme Court. Or you should have been practicing in one of the high courts for at least 10 years. You will be appointed by the government, by the President of India. This can come as a 1 mark or an MCQ kind of a question. The retirement age for judges of the Supreme Court is 65. They retire at the age of 65. If he has to resign, the resignation is sent to the President of India if any judge has to resign. How is the CJI, the Chief Justice of India, appointed? The outgoing Chief Justice of India recommends the name of his successor. Jo abhi ke CJI honge, before he is going to retire, due date of his retirement, he will recommend that so and so, and usually it is the senior most judge of the Supreme Court whose name is recommended by the outgoing Chief Justice of India to be his successor, to become the next Chief Justice of India. The oath of office is given by the President of India. Okay, so please remember this. Chief Justice of India gives the oath of office to the President. President gives the oath of office to the CJI. ये आपस में करते हैं. Okay, the appointment is done by the President, the name of the President. The other judges are also appointed by the President of India, but he has to take the opinion of the CJI, and the CJI has to consult a collegium of 4 other Supreme Court judges. There can be appointment of ad hoc judges also, यानी कि temporary basis पे judges appoint किया जा सकता है for a certain period, and this has to be again with the consent, with the approval of the President and the Chief Justice of the High Court. Okay, suppose आप आंध्र प्रदेश हाई कोर्ट में से एक जज को सुप्रीम कोर्ट का जज टेम्पररी बेसिस पे बना रहे हैं, सो चीफ जस्टिस ऑफ द आंध्र प्रदेश हाई कोर्ट की परमिशन लेनी जरूरी है, उनको कंसल्ट करना जरूरी है. Okay, even retired judges of Supreme Court or High Court can be asked to become the judge of the Supreme Court on a temporary basis, on an ad hoc basis. Okay, let's come to the impeachment of judges. Impeachment of judges, just like in the case of the President, is done on the grounds of proved misbehavior or incapacity. कि कोई इस तरह का conduct हो जो कि शर्मनाक हो, और incapacity मतलब if that person is not able to discharge his or her duties, then also he can be impeached. How is the impeachment done? The address by each House of Parliament, similar to that of the President, supported by majority of the total membership of the House and by a majority of not less than 2/3. ये पूरा legal और constitutional language है, इसको याद रखिएगा, notes में लिखा हुआ है. Okay, remember the exact words. Two cases it has happened. 1993 में Justice Ramaswamy, I remember, but his impeachment failed to get the support of the total membership of the Lok Sabha. In 2011, Justice Soumitra Sen of the Calcutta High Court on charges of corruption, he resigned because the Rajya Sabha passed the impeachment motion, but Lok Sabha में नहीं आया था, उससे पहले उन्होंने resign कर दिया था. Okay. So, and then he's removed after the proceedings completed. अभी तक कोई भी नहीं हुआ है impeach. Now, how is the independence of the judiciary maintained? How is it ensured? Number one, this is an important question. Please listen to this carefully. सबसे पहली बात, in the appointment of judges, every judge is appointed by the president. Of course, that's a formality. After consultation with the judges and the cabinet. The cabinet government also has a role, but it's the judges, the collegium of the Supreme Court, a group of senior judges of the Supreme Court who decide that so and so person can be promoted as a judge from one of the high courts to the Supreme Court. Then it is sent to the cabinet for approval, and then the cabinet approves and sends it to the president for his signature or her signature, right? So इसका मतलब ये नहीं है कि judges are appointed by the government. They are also part of the consultation process. Okay, so if the government has to have an objection, it has to have some very serious reasons why it should object to a particular judge. Otherwise, it is the Chief Justice of India in consultation with the senior most judges, usually 4 judges, who decide on who will be promoted as a Supreme Court judge. Number 2, this is how the independence of judiciary is ensured. Number 2, removal of judges. It can happen only by impeachment. The government cannot decide. Parliament can decide. If parliament में वो impeachment के लिए उतने numbers हैं तो ठीक है. लेकिन government cannot decide. Okay, so the charge needs to be proved by the members of parliament to vote, and proof is very important. Proof लाना जरूरी है. Without proof किसी को भी impeach नहीं कर सकते हैं. And the charges to be examined by an impartial authority also. In it, the whole thing has to be investigated by members of parliament. You know, it's not like, you know, everybody can become a group and say that is judge ko hatao. There is security of tenure, that is till you are 65 years of age, you will remain a judge of the Supreme Court. किसी को तुम्हारी शक्ल पसंद नहीं आती या तुम्हारा कोई वर्डिक्ट पसंद नहीं आए तो तुमको निकाल नहीं सकते हैं. Security of salaries, that is salaries cannot be reduced except under financial emergency. When it is a financial emergency, then your salaries can be reduced, right? And the salary is drawn from the consolidated fund of India, and therefore it is not subject to a vote of parliament. Parliament can increase the salaries. It cannot decrease the salary. It cannot do anything to the disadvantage of the Supreme Court judge. Okay, salary increase is done by parliament. Okay, but it is drawn from the consolidated fund of India. Contempt of court. Supreme Court can punish any person if any person behaves in a manner that lowers the dignity of the Supreme Court. Okay. Freedom to announce verdicts, that is, it cannot be criticized usually, and duty of the state to ensure their personal safety. कि जज ने कोई टेरर केस में जजमेंट दे दिया, फांसी दे दी या लाइफ imprisonment दे दिया, ऐसा नहीं है कि नो कि when he is going back home or is going on his morning walk or somewhere he gets shot at. So his security is the responsibility of the government of India, of the state. Okay. Then no discussion in legislature. If there is a verdict given by the Supreme Court, it cannot be discussed in parliament or in any legislature in India. It cannot be said कि ये judgment बेकार था और ये judgment बहुत अच्छा था. It cannot be discussed in parliament. The only time Supreme Court can be discussed is if in impeachment proceedings are done. Okay. No practice after retirement. This is important. Okay. The judges are paid very good salaries, so they are not allowed to work after retirement. और इसका reason क्या है and why is this important? This can come as a question. This is done so that the judges are not influenced. You understand? While they are in office, I am a judge. मेरे सामने एक case है of a prominent industrialist, right? I give a favorable judgment. And then after I retire at the age of 65, go and join that particular company, maybe as an advisor, maybe as a consultant. That cannot happen. Because that will mean that I was influenced to give a decision in the industrialist's favor because I was expecting monetary benefits. I was expecting employment opportunity after I retire. So a Supreme Court judge is not allowed to work anywhere after retirement. Halaki ajkal, though it's not the same thing, they become Rajya Sabha members, etc. If they are allowed to practice, the other reason is that if they are allowed to practice, suppose you become an advocate, you become a lawyer, okay, then you will come and argue your case in the court of judges who were junior to you, because you have retired as a judge at the age of 65. These people are junior to you. That's why they're still continuing as judges. So that can put pressure on the judges and it can influence the judiciary. तो इस वजह से सुप्रीम कोर्ट जज को प्रैक्टिस करने की अनुमति नहीं दी जाती है. Okay. Last point, full control over procedures. That is, they are free from the any kind of influence of any outside agency. Let's now come to part 2 of the Supreme Court chapter, which is about jurisdiction. This is really legal language. ध्यान से सुनना. Pause कर लो, पानी पी के आ जाओ so that you are more fresh. This is tricky. Okay. Now, what is jurisdiction? पहले इसको समझो और इसको मैं ध्यान जितना सिंपल लैंग्वेज में हो सके उतना सिंपल लैंग्वेज में समझाने की कोशिश करता हूं. Jurisdiction is the power that a court of law exercises. यानी कि एक अदालत के पास वो अधिकार, वो ताकत है कि जिससे it gives judgments in important cases and enforces the law of the land. कि कॉन्स्टिट्यूशन के इस लॉ के अंदर ये जो बात की है ये गलत है या ये ठीक है और इसकी वजह से हमारा ये जजमेंट है. ओके, सो इट इज द पावर that a court of law has to carry out judgments or give out judgments and enforce laws. This is called jurisdiction. Okay. And the Supreme Court, this comes as a 1-mark question. Supreme Court is the final interpreter and protector of the Constitution. Yani ki Constitution में भी legal language भरा हुआ है. Okay. Because it was drafted by lawyers led by Dr. Bhimrao Ambedkar. So, उस कॉन्स्टिट्यूशन को इंटरप्रेट करने के लिए कि कॉन्स्टिट्यूशन में असल में लिखा क्या गया है और उसको, बिकॉज कॉन्स्टिट्यूशन लिखा गया था 1950 में, उसको अभी 21st सेंचुरी में इंटरप्रेट करने के लिए भी एक तरह से लीगल माइंड चाहिए. तो उसके लिए सुप्रीम कोर्ट इज कंसिडर्ड द फाइनल इंटरप्रेटर and protector of the constitution, that the government or anyone else in the country should not do anything that goes against the constitution and therefore my rights as a citizen of this free country. समझ में आ गया अभी तक? Now, there are 3 forms of jurisdiction. पहला है original jurisdiction. What is original jurisdiction? Original jurisdiction means the power to hear and determine a dispute. Okay, I think. Okay. Here a dispute. जो केसेस सीधे के सीधे सुप्रीम कोर्ट में आते हों. Disputes that cannot be heard in any other court other than the Supreme Court. सीधा का सीधा सुप्रीम कोर्ट में आके सुनवाई होगी. हाई कोर्ट या सेशंस कोर्ट या डिस्ट्रिक्ट कोर्ट में जाने की जरूरत नहीं है. What kind of cases fall under original jurisdiction? Center state or state interstate disputes. यानी कि भारत सरकार और लेट्स से महाराष्ट्र सरकार के बीच में कोई विवाद है. Okay. Now, can it be heard in the Bombay High Court? Bombay High Court तो महाराष्ट्र के अंदर है. Can it be heard in the आंध्र प्रदेश हाई कोर्ट? No, because आंध्र प्रदेश का तो jurisdiction ही नहीं है. ये सेंटर और महाराष्ट्र के बीच की बात है तो आंध्र प्रदेश का कोर्ट हाई कोर्ट कैसे करेगा? So all such cases will go directly to the Supreme Court. Or let's assume a dispute between 2 states, let's say Madhya Pradesh and Chhattisgarh. Can it go to either of those high courts or can it go to a third high court? No. So such cases will also come to the Supreme Court. समझ में आ गया? Number 2, these do not extend to cases where disputes arising out of a treaty, agreement, or matters referred to the Finance Commission or adjustment of expenses between the center and the states. हालांकि Kaveri dispute etc. finally came to the Supreme Court because it was a river water dispute. Despite the tribunal etc. nahi hua, so there were disputes over the distribution of water, okay, between Karnataka and Tamil Nadu, and of course Kerala also was a party to it. Number 2 is protection of fundamental rights, where cases of violation of fundamental rights of individuals, okay, and the courts can issue what are called writs, जिसके बारे में हम बाद में पढ़ेंगे, for enforcement of these rights. कि इस writ का मतलब orders जिसकी वजह से those fundamental rights, I as a citizen have the rights, have the fundamental rights, आपने क्लास 9 में पढ़ा है, तो उसको कोई भी वायलेट नहीं कर सकता है. तो अगर आपको लगता है कि कोई उसको वायलेशन कर रहा है, आप पूरी तरह से सुप्रीम कोर्ट में जा सकते हैं and say that my fundamental rights are being violated, please protect me, and the Supreme Court will do that under original jurisdiction. समझ में आया? Third one, transfer of cases from lower courts. Now, what happens is that Supreme Court can transfer cases to itself from one or more high courts. अगर एक या दो high courts में similar kind of cases are being heard. आजकल काफी चल रहा है कि किसी ने कुछ बोल दिया, controversial बोल दिया, उसके खिलाफ multiple cases are filed. Madras High Court, Kerala High Court, Karnataka High Court, Bombay High Court, 4-5 अलग अलग, Guwahati High Court. Now the same person cannot be going from court to court सुनवाई के लिए. So he can appeal to the Supreme Court that I am being harassed by different people who are filing similar cases, क्योंकि मैंने किसी टीवी इंटरव्यू में ये बोल दिया था, तो सभी अलग अलग जगह पे मेरे खिलाफ केस फाइल कर रहे हैं, तो प्लीज ट्रांसफर ऑल द केसेस टू द सुप्रीम कोर्ट ताकि मैं एक ही जगह पर इसकी सुनवाई हो जाए. तो द सुप्रीम कोर्ट कैन ट्रांसफर ऑल सच केसेस फ्रॉम different high courts, club them together and hear them together. This will involve questions that are important or involve questions of law. Okay. Interpretation of the Constitution. Final interpreter वही है, तो Supreme Court के पास सीधा जाके सुनवाई हो सकती है wherever it involves a question about the interpretation of the Constitution. यहां तक समझ में आ गया? नहीं आया तो just rewind करके फिर से सुन लो. Notes भी हैं, but सुन लो ताकि or any doubts please ask. Appellate jurisdiction. अब ये Apple वाला क्या है? Now appellate jurisdiction is the power of the Supreme Court. ये वर्ड्स आपको वही याद करने पड़ेंगे, तो थोड़ा सा मैं I don't like to use the word रट्टा मारना पड़ेगा, लेकिन आप लिख के लिख लेंगे, कीवर्ड्स याद रखेंगे तो याद हो जाएगा. Appellate jurisdiction is the power to grant special leave to appeal against judgment delivered by any lower court. अभी भला है क्या बात? Easy language में समझाता हूं, और मैंने नोट्स में भी easy language में लिखा है. Anyone can appeal in the Supreme Court against the verdict given in a high court. आपको राजस्थान हाई कोर्ट में एक वर्डिक्ट मिला जो कि आपको पसंद नहीं है. It has gone against you. Okay, you can appeal in the Supreme Court. Okay, now this makes the Supreme Court the court of appeal, which can change the verdict of the High Court. ऐसा होता भी है. I'll tell you the famous case of the Jayalalitha disproportionate assets case in 2015 था. पहले लोअर कोर्ट बैंगलोर में, जो कि उनकी स्पेशल कोर्ट which was listening to the case, after almost 2 decades, it delivered a verdict and sent Jayalalitha to jail. Okay, she came out on bail. Then the case was heard in the Karnataka High Court. They appealed in the Karnataka High Court. Karnataka High Court reversed the decision and acquitted her. यानी कि बोल दिया कि ये बेगुनाह है, Jayalalitha को free कर दिया. Okay. Then the case was heard in the Supreme Court. In 2016, the verdict came. 2017 February में, 10th of February or something, I remember. I was in Chennai reporting on it, and it held Jayalalitha, who had died by then, guilty, and therefore the 4 other people led by V.K. Shashikala were all sent to 4 years in prison. So ऐसा भी होता है कि लोअर कोर्ट एक देता है, हाई कोर्ट उसको उल्टा कर देता है, and Supreme Court उसका भी उल्टा कर देता है. दैट मींस सुप्रीम कोर्ट एंड लोअर कोर्ट आर ऑन द सेम पेज. हाई कोर्ट अलग देता है. सो people can go in appeal to the Supreme Court is what I'm trying to tell you. Okay, so that can happen. What kind of cases can this happen? It can happen in constitutional cases. It can happen in civil cases. It can happen in criminal cases also. Okay. Now, constitutional cases, all matters where the High Court says that this case needs interpretation. तो Supreme Court में जाओ. तो अगर हाई कोर्ट बोलता भी नहीं है तब भी सुप्रीम कोर्ट सुन सकता है अगर मैटर इन्वॉल्व्स इंटरप्रिटेशन ऑफ द कॉन्स्टिट्यूशन. हालांकि हाई कोर्ट आल्सो कैन इंटरप्रेट द कॉन्स्टिट्यूशन, बट इफ वन ऑफ द टू पार्टीज ऑब्वियसली डजंट लाइक इट, they can go in appeal to the Supreme Court. Okay. Or number two, civil cases where it involves a question of law of importance and if it decides to be need. Say for instance, civil cases kaise hote hain? Some property case mein or something to do with the hijab controversy. These are all kind of civil kind of cases. Third one is the criminal case. Two kinds of appeals go to the Supreme Court in criminal cases. With certificate of Supreme High Court or without certificate. इसका मतलब क्या है कि विद हाई कोर्ट बोले कि आप सुप्रीम कोर्ट में जाओ या हाई कोर्ट ना बोले सुप्रीम कोर्ट में जाओ, सर्टिफिकेट देना सर्टिफिकेट नहीं देना. ओके. नाउ सर्टिफिकेट ऑफ हाई कोर्ट इज नॉट नीडेड इफ द हाई कोर्ट हैज रिवर्स द जजमेंट ऑफ एक्विटल गिवन बाय लोअर कोर्ट. यानी कि लोअर कोर्ट ने फ्री कर दिया, इनोसेंट डिक्लेयर कर दिया और हाई कोर्ट ने उसको रिवर्स किया हो. ओके. और एक्यूज को बोला हो कि डेथ सेंटेंस होगी, फांसी की सजा होगी. ओके. इन मर्डर केसेस और इन हीनियस क्राइम्स एटसेट्रा, रेप केसेस एटसेट्रा, दिस कैन हैपन. ओके. एंड सुप्रीम कोर्ट कैन टेक इट इवन विदाउट द सर्टिफिकेट ऑफ द हाई कोर्ट. सर्टिफिकेट की जरूरत नहीं है. और अगर हाई कोर्ट ने केस लोअर कोर्ट से विड्रॉ करके डेथ सेंटेंस, जहां डेथ सेंटेंस का सवाल आता है, सुप्रीम कोर्ट हैज टू लिसन टू इट. ओके. तो इस बात का आप ध्यान रखिएगा. Now, the question that arises is, and this can also come as a question, how is the Supreme Court a court of appeal? Because it is a court that can change the decision of the lower court, that's a high court, or reduce the sentence passed by the lower court. It is a final court of appeal. यानी कि जो निचली अदालत ने कोई भी वर्डिक्ट दिया है उसको वो बदल सकता है. Okay, so that's why it's called the final court of appeal. Then we come to revisory jurisdiction. इसके पहले there is also something called the advisory jurisdiction, which is the power to advise the president on any question of law or matter of public importance, but the advice is not binding on the president. Okay, nor it is to be considered as a verdict. Then we come to revisory jurisdiction, which is the power to review its own verdict. भला क्यों? Why should, if Supreme Court ने verdict दे दिया, why should it review the verdict? Because उसमें अगर कोई गलती हो गई हो तो उसको रिवाइज करके, जैसे आप रिवाइज करते हैं ना एग्जाम फाइनल आंसर शीट देने से पहले, तो उसमें कोई गलती हो गई हो तो उसको रिवाइज करने के लिए इट्स कॉल्ड रिवाइजरी ज्यूरिसडिक्शन. एंड दिस इज इंपॉर्टेंट बिकॉज द सुप्रीम कोर्ट इज अ कोर्ट ऑफ रिकॉर्ड, बिकॉज उसको बाद में साइड किया जाता है. अरे सुप्रीम कोर्ट में इसके स्टेट वर्सेस सो एंड सो के केस में ये वर्डिक्ट दिया गया था तो ये केस भी सिमिलर है, सो दिस ऑल्सो शुड हैव अ सिमिलर वर्डिक्ट, सिमिलर जजमेंट करके उसको कोट किया जाता है. तो अगर वो वहां पर गलती होगी, इफ देयर वाज अ मिस्टेक मेड अर्लियर, द सेम मिस्टेक विल बी रिपीटेड इन द अदर केस आल्सो. सो देयरफॉर द सुप्रीम कोर्ट हैज रिवाइजरी jurisdiction which can remove any error that may have crept into the judgment. Okay, this is under article 137 if you may remember. Then we come to judicial review. Judicial review is the power to check constitutional validity of law passed by the legislature, parliament. Okay, which means, what this means is that अगर legislature ने कोई law pass किया हो, somebody goes to Supreme Court कि ये this is against the law of the land. Okay, so the Supreme Court can examine कि whether the law has been made as per the Constitution of India, because it's the interpreter of the Constitution of India. So it can legally examine कि under the law whether this is fine or not, or if it is not, it can declare it null and void, which is called ultra vires. Okay, that it is not in accordance with the Constitution of India, कि ये संविधान के अनुसार नहीं बना है. It is against the letter and spirit of the Constitution. This is called the power of judicial review. याद रखना, power of judicial review? This is one of the favorite questions asked in the board examinations. And whenever such a case is to be decided, there have to be 5 judges who should be part of the judicial review bench. Okay, and usually the Chief Justice of India heads the bench. Okay, so it will be 5 senior judges who will be part of such a judicial review. Then we come to court of record. Why is it a court of record? Because it's a court whose judgments are recorded for evidence, जैसे मैंने अभी समझाया, and testimony. बाद में इसको cite किया जाता है, cited as precedents in a similar case in any court of the country. पटना हाई कोर्ट में सिमिलर केस हो तो पटना हाई कोर्ट विल सुप्रीम कोर्ट वाले केस को साइट करेगा. ओके, एंड देयरफॉर इट इज नोन एज द गार्डियन ऑफ द कॉन्स्टिट्यूशन. ओके, नाउ लेट्स कम टू द रिट्स. This is important. What is a writ? Writ is an order given by a court or any legal authority to act or abstain from acting. To act or not to act in a particular way. Abstain matlab nahi karna, right? To act or abstain from acting in a particular way. So it's an order. और इसमें 5 तरह के writs generally होते हैं, उसके बारे में आपको पढ़ना है. First one is habeas corpus, which is probably the most used writ. In Latin, it means show me the body. Okay, or give me the body, but generally show me the body. What it means is that by issuing this writ, the court can get the body. In what cases it is used? I mean, since I've covered a lot of Naxalism and Maoism, पहले होता ये था, अभी भी होता है वैसे, अभी ज्यादा नहीं होता है, that some Naxal leader would be picked up by the police. Okay. But police will be not showing the arrest. They would have picked him up but not shown the arrest formally, because within 24 hours you have to produce the person before a magistrate. But sometimes many unlawful arrests are made by the police because they want to get more time to interrogate the person who they have picked up. So the family of the Naxal, usually family of the Naxal who are overground or any other sympathizers or any other human rights activists will go to the court and say and file a writ under habeas corpus saying that we suspect this person has gone missing. We suspect that the police has picked him up. So ask the police to produce it. So either the police has to file an affidavit saying that हमने कुछ नहीं किया, अगर उन्होंने नहीं किया है, और अगर किया है तो उनको produce करना पड़ेगा. They will have to show a formal arrest or they will have to release him. It can also happen in cases where, say, somebody has been kidnapped, abducted. In that cases also, you can file a habeas corpus saying that we suspect that so-and-so person has kidnapped this person. So we file this writ under the habeas corpus. So the Supreme Court can ask the police to investigate and produce this particular person who has gone missing. Okay, so it's a great safeguard for personal freedom of a citizen, and it kind of safeguards the citizens against unlawful detention, यानी कि illegally detain किया हो. Okay. Writ of mandamus, which means we order, and it is an order from a superior court to a lower court to perform some duty. Okay. Third one is the writ of prohibition. It is an order issued to stop proceedings because it may be in excess of jurisdiction of lower court. पता चले कि लोअर कोर्ट में ये अधिकार नहीं है कि आपका ये टेरिटोरियल jurisdiction नहीं है कि आप ऐसे केस पर डिसीजन ले सके. So under the writ of prohibition, the Supreme Court can order to stop proceedings, okay, of the lower court. Suppose the Bombay High Court is hearing a case which actually pertains to Gujarat, then it can step in and say that this is not coming under your jurisdiction. The writ of certiorari, it is desiring to be informed about what is going on, which means that it is again by the superior court to the judicial authority. The difference between writ number 3 and writ number 4 is that writ number 3 is issued when certain proceedings are going on, whereas writ number 4 is issued after the order has been passed by the lower court. That the Supreme Court says that we wish to be informed about what is going on. Okay. Quo warranto, the last one. It means by what order? It prevents government officers from forcibly holding a high public office. कहीं forcibly दूसरे के दफ्तर में घुस के you start occupying that particular office. Under quo warranto, the Supreme Court can say by what order are you occupying this particular position. What exactly is a high court? Okay, now high courts are the highest grades of the judicial system in every state and or union territory, right? Now, according to the Constitution, Article 214, you don't really need to remember, every state has a high court operating within its territorial jurisdiction. Territorial jurisdiction का मतलब क्या है? अगर ये है राजस्थान का मैप, राइट? सो राजस्थान के अंदर राजस्थान हाई कोर्ट का jurisdiction रहेगा. Jurisdiction के बारे में we have already explained in the Supreme Court chapter. So whatever a case pertaining to say Chhattisgarh will not come before the Rajasthan High Court. Understood? It will hear matters within the territory of the geographical territory of Rajasthan. Okay. There will be a high court for every state, but there could be a common high court for two or more states. For instance, Punjab and Haryana High Court. Okay. It is shared between the two states of Punjab and Haryana, just like they share the capital Chandigarh. There are 25 high courts in the country, right? Kerala High Court has the jurisdiction over Lakshadweep. No, I said no, there are union territories which are under the jurisdiction of another high court which may not be in its territory. Madras High Court has jurisdiction over Puducherry or Pondicherry. Calcutta High Court has jurisdiction over Andaman and Nicobar Islands. Okay, now in terms of hierarchy, Supreme Court is the supreme one. But as I said, Constitution of India provides for a high court in every state, but they could have a common high court for two or more states based on the area, population, and the kind of work it needs to handle. Okay, the Bombay, Calcutta, and the Madras high courts were all established in 1862. So they are the oldest high courts in the country. Does the state executive and legislature control the high court in the state? No. Do union territories have written all these question and answers which you can go through? Okay. Delhi is the only union territory state. It's also a state, but it's also a union territory which has its own high court. Now let's come to the composition of the high court. It consists of a chief justice of that high court and judges. The judges are not a fixed number like in Supreme Court. They differ from state to state. They're all appointed by the president. The judges of the high court, the chief justice of that high court, and the judges are all appointed by the president. Now, the president can also appoint additional judges for a temporary period, right? Not exceeding 2 years. An acting judge can also be appointed when a permanent judge, not the chief justice, because if the chief justice is not there, the senior most is appointed as the acting chief justice of that high court. Okay. When a permanent judge is temporarily absent, maybe ill or for whatever reason, then they can appoint a temporary judge also. Okay. But they cannot be more than 62 years of age. That is the age limit. Okay. So what are the qualifications to become a high court judge? Citizen of India, not above 62 years of age. Supreme Court mein 65 tha. So please remember this difference. He should have held a judicial office for 10 years or he should have been an advocate of the High Court for 10 years, any High Court. The qualification of eminent jurist, which is there in the case of the Supreme Court, was not there in the case of the High Court. Okay. Appointment. How is the High Court judge appointed? The oath of office is given by the governor of that state or the chief justice of the High Court. Okay. They are appointed by the president of India in consultation with the chief justice of the Supreme Court and the governor of the state and the other judges of the High Court. This is the chief justice. The other judges of High Court are appointed by the president in consultation with the chief justice of India, the chief justice of that High Court, and the governor of the state, not the chief minister of the state, the governor of the state. A high court judge can be transferred from one place to another. He can be impeached. We've already discussed that in 2011, the Soumitra Sen case about which I mentioned in the Supreme Court chapter. The salaries and the allowances of high court judges cannot be changed to their disadvantage because unless it's a financial emergency, pretty much similar to the Supreme Court chapter. They're charged on the Consolidated Fund of India. वहां से उनकी salaries और allowances आती हैं. So state legislature, Telangana High Court के जो judges की salary cannot be decided by the Telangana Legislative State Assembly. Okay, so please remember that. Can a High Court, he sends his resignation to the President of India. Can he practice after retirement? He can practice only in the Supreme Court or in those High Courts where he has not served as a judge. This is important. Okay, let me just move the table closer. Now let's move to the jurisdiction of the High Court. As I said, both Supreme Court and High Court chapters are pretty similar in many respects. The jurisdiction in this case is limited to the territory of the state. That's it. Supreme Court can deliver a verdict pertaining to any part of the country. The Calcutta High Court can deliver a verdict only pertaining to West Bengal. Okay, in this, let's now understand what is original jurisdiction. The power to hear and decide cases at the first instance, pretty much like the Supreme Court. What are the kind of cases? Matters of state revenue, their collection, marriages, divorce, wills. Wills का मतलब समझते हैं ना, कोई मरने से पहले will छोड़ के जाते हैं. Contempt of court, company matters, interpretation of the constitution, which High Court also does. Of course, it can be taken to the Supreme Court also. Enforcement of fundamental rights, election petitions, yani ki I lose an election, I challenge the election of the candidate who has won, saying that he had resorted to malpractices, he had bribed voters, or his election affidavit is containing incorrect information. I can challenge it in the High Court of that particular state. So if there is an election concerning, say, the state of Karnataka, I will go to the Karnataka High Court. What is appellate jurisdiction? As I said, pretty much same. Power to accept appeals against the decisions of the district court. Supreme Court में क्या था? Lower courts, यानी कि High Court. High Court में क्या है? The lower court, which will be the district court. And this applies both to civil as well as criminal cases. Civil में matters of state revenue, right? और अगर कोई judicial authority ने कुछ which the person feels has done some injustice, right? They can set aside or dismiss the order of the tribunal. In criminal cases, agar death sentence has been passed by the lower court, it has to be confirmed by the High Court. Please remember this. A death sentence, agar ki murder case mein lower court ne, sessions court ne death sentence sunaya ho, that person cannot be hanged immediately. It has to be confirmed by the High Court of that state. So agar koi death sentence has been delivered by, say, the sessions court in Tirunelveli in Tamil Nadu, okay, it has to be heard by the Madras High Court. Similarly, other appeals include judgment of sessions judge where sentence of imprisonment exceeds 7 years, or in the case of judgment of assistant sessions judge where the sentence exceeds 4 years. These are all technicalities. Aap notes mein isko padh sakte hain. Let's move to the functions of the High Court are similar. Settlement of disputes, same original, as well as on appeal, similar to the original jurisdiction and the appellate jurisdiction. Now, what are subordinate courts? Now, every district in the country, and there are over 750 districts in the country, every district in the country has a separate civil court, criminal court, and a court of revenue. Okay. All the courts except the Supreme Courts and the High Courts are known as the subordinate. Subordinate matlab nichla, lower. That is, I am subordinate to him. So this court is subordinate to the High Court and the Supreme Court. Okay, so this is the hierarchy. Supreme Court upar ho gaya, High Courts, and then a system of so many district courts, sessions courts in over 750 districts of India. Now, what is the distinction between a district judge and a sessions judge? This is another favorite question in the board examination. Now, the court of the district judge and the sessions court ke beech mein differences पूछे जाते हैं. The court of the district judge is the highest civil court. DC. तो CD करके आप याद कर सकते हैं. Civil district judge. Okay. So civil, this thing is the one. SC, Sessions Criminal, आप इस तरह से उसको याद रख सकते हैं. तो हाईएस्ट सिविल कोर्ट को कोर्ट ऑफ डिस्ट्रिक्ट जज बोलते हैं. He listens to cases involving land revenue, property, marriage, divorce, wills, etc. And it is presided by a district judge. Okay. Sessions court is the highest criminal court. Murder हो गया, theft हो गया, pickpocketing हो गया, robbery हो गया, rape हो गया, molestation ho gaya, all these cases are heard by the sessions court, okay, which have a criminal angle to it. It is presided over by the sessions judge. Okay. Now, if I ask you a question, sessions judge mein or high court judge mein kaun superior hai? Obviously High Court. So please understand the hierarchy. इसमें तीन चार differences और हैं. These are the main three differences. The district judge and the additional district judges are appointed by the governor of the state in consultation with the chief justice of that particular high court. He has no control over cases pertaining to agricultural matters. Such cases are heard by the revenue courts. Land के cases में revenue courts come into the picture, not civil वाले. इसमें land का होता है property if it is a normal land, but agricultural land का जहां पे बात होता हो, it goes to the court of revenue. Exercises control over all the civil courts in the district, that is the district judge. जो छोटे और भी मंडल लेवल पे रहते हो, गांव में रहते हो, so those come under the control of the district judge. The sessions court, the other differences are not much. The sessions court and the additional sessions court are also appointed by the governor in consultation with the chief justice of the specific high court of that particular state. Let's move over to Lok Adalat. Lok Adalat, Lok Adalat. Lok matlab log, Adalat matlab court. So it's a people's court and it's based on Gandhian principles. Yani ki cheap legal advice should be provided, help should be provided to all people who cannot afford, high profile lawyers who charge by the minute. Okay, this Lok Adalat concept was started in the 1980s, that is over 40 years, on the recommendation of Justice P.N. Bhagwati. Okay, very eminent Chief Justice of the Supreme Court. It is basically a legal forum to provide legal aid and quick justice to those who cannot hire lawyers or bear expenses of legal proceedings. Okay, because lawyer fees etc. are very, very high in most of the cases. पहला लोक अदालत हुआ था जूनागढ़ में 1982 में, लेकिन उस समय तक the Lok Adalat Act was not passed. That was passed only in 1987. Legal Services Authorities Act of 1987. Okay. All the decisions of the Lok Adalats are deemed to be decrees of civil court. Decrees matlab verdicts of civil court, and are binding on the parties. यानी कि see, it operates on the basis of settlement. दोनों parties को बुलाया जाता है. अदालत, normal अदालत में वाद विवाद होता है. You try to prove the other party wrong. In Lok Adalat, the big difference is that you call party A and party B. You say that okay, let's arrive at a compromise. तुम थोड़ा सा दो, तुम थोड़ा सा compromise karo, so that you can arrive at this thing, so that the same case, if it goes to the court, it will drag on further. The two parties will have to pay to the lawyer, and it will involve a lot of time, and it will also involve add to the burden of the main court. So this was an attempt to kind of जो छोटे मोटे cases हैं जो कि settlement और बातचीत से सुलझाए जा सकते हैं, which can be solved through dialogue, they could go to the Lok Adalat. Okay, so they are considered to be decrees, verdicts of the civil court, and are binding on the people. But subsequently, the Supreme Court said that the Lok Adalat का जो verdict है, that cannot be cited as a precedent. कि उस Lok Adalat में ऐसा दिया था, तो यहाँ पर भी similar case में ऐसा होना चाहिए. That cannot happen. So it will not be cited as a precedent, because the purpose is to only arrive at a settlement between the two parties. Now, the other important question that is normally asked is, what are the purposes of a Lok Adalat? Quick legal aid and justice, which I mentioned. They relieve the courts of the heavy backlog of cases, because as I said, ये सारे cases वहां पे जाएंगे तो obviously वहां पर ज्यादा backlog होगा, so that doesn't happen. And it eliminates high cost and delay in giving justice. High cost of paying to the lawyers and delay in giving justice. What are the advantages of Lok Adalat? They play a role in settlement of disputes in the spirit of compromise, that, I compromise something, you compromise a bit, and we arrive at a mutual settlement. Okay, to deliver fast and inexpensive justice, no court fee has to be paid. It reduces the workload of the other courts, and it promotes social justice, that, people are given justice at a very lower level, at the village level, at the mandal level, at the Zilla Parishad level, etc. Okay, so those are the advantages. Then you also have something called the family courts for speedy settlement of disputes pertaining to matters involving family, marriage, and family affairs. Okay, so family courts are usually set up in cities which have a 10 lakh plus population. Halaki, the recommendation is that every district should have a family court in India. That is the recommendation. Also, there are many public sector organizations which kind of regularly organize Lok Adalats in order to settle minor disputes. मैंने bill pay किया लेकिन वो show up नहीं हुआ, या मेरे को electricity bill आया 75,000 rupees का आया, नॉर्मली मेरे को सिर्फ 2000 का आता है, 75,000 रुपीज का मेरे को इलेक्ट्रिसिटी बिल आया. सो do you go to court for something like that? Lawyer fees itself will be more than 75,000. So you go to a Lok Adalat, which will be organized by, say, the power department, the electricity department, and settle the issue without having to pay any kind of court fee. So that is the objective of a Lok Adalat. Now, what I want you to do is, I want you to revise both the judiciary chapters one after the other, because judiciary chapters को समझने में थोड़ी सी मुश्किल हो सकती है. You may struggle a bit. So please go through the videos 2x speed pay. You can go through it twice so that you understand it very well, because there are certain legal terms which can confuse you. Googly हो सकता है. Okay. Tata, bye bye. Thank you very much for watching.